Kevin Franke has now sued Jodi Hildebrandt. He's suing her in civil court for money damages. So now that Jodi and Ruby's, their criminal cases have concluded, they're going to be serving their sentences at least 4 years, at maximum 30 years. That's going to be decided by the parole board. So that criminal case essentially has concluded, and now Kevin Franke has sued Jodi Hildebrandt in civil court, seeking money damages. Now, you may be thinking right away that, oh, well, this should be an open and shut case. After all, Jodi Hildebrandt got up and admitted she pled guilty to these counts of child abuse. So isn't that a slam dunk case? And the answer to that is not necessarily. Why? Because we have to keep in mind who the plaintiff here is. Now, of course, you're going to be hearing a lot about the torture that the children went through, but the plaintiff here is not the children. Now, do the children have a cause of action against Jodi Hildebrandt? Absolutely, 100%. But this is not a case that was filed on behalf of the children. This is a case that has been filed on behalf of Kevin Franke for his personal pain and suffering, mental anguish, emotional distress. That is what he's alleging that he had as a result of Jodi's actions, the way that she tortured his children. So it's more remote than the actual torture that she was doing to his children. It's the effect that eventually had on Kevin himself. So that's a little bit different, and therefore it may get a little more complicated whether this is actually these causes of action, whether this lawsuit has any merit to it. So that's what we're going to be discussing today. We're going to be jumping into that. Now, there are a number of different factors that a plaintiff attorney has to take into consideration before filing a lawsuit for a plaintiff. And one of the most important ones, is whether the defendant is collectible. Meaning you can go and spend a lot of time on a lawsuit. You can do everything perfectly, win the case, get a $5 million verdict, and now the defendant is just uncollectible. There's no assets. He doesn't have anything to collect your money for. So you just wasted your time. So one of the things as a plaintiff attorney you have to do is figure out whether the defendant, or have an educated guess whether the defendant is collectible. So that's number one. Is Jodi Hildebrandt collectible or not? Does she have all these assets? Does she have some stocks and other investments? That you would assume that the plaintiff attorney did some research on and discovered that there is. Alternatively, there's other reasons to bring a lawsuit, especially when you have a very public case like this. You're going to get a lot of good publicity. So even if the actual case is not going to be collectible, but people are going to see you on the cameras, they're going to hear about you, they're going to be talking about you, and that may lead to other business. So that also may be worthwhile taking on a case like this as well for those purposes. But either way, let's jump into the allegations here and let's see whether there is a valid, meritorious cause of action for Kevin Franke. So let's go through some of the complaint. We're not going to read through everything, but some of the main parts. The plaintiff is the father of 4 minor children, to wit, AF, JF, RF, and EF. And of course, it doesn't name the actual children in the complaint because they're minors. While plaintiff was residing in Utah County beginning on or about May 22nd, 2023, defendant, meaning Jodi Hildebrandt, in collaboration with plaintiff's then-wife, Ruby Franke, also mother of these 4 children, moved the 4 minor children to defendant's home in Ivins, Utah. Neither defendant nor Ruby Franke advised plaintiff of the removal of the children from the family home in Springville, Utah, to defendant's home in Ivins, Utah. For the period of time May 22nd through August 30th, 2023, while at the defendant's home, defendant did intentionally and or recklessly and or negligently do the following. So if you have sensitive ears or if you just ate, I wouldn't recommend listening to the next part. We're going to go through some of the allegations that the torture that was done to the children. Number 1, wrongfully detained plaintiff's 2 minor children, RF and EF, ages 11 and 9, often confining them to a room in the home and or basement of the home from which they were not allowed to leave without the permission of the defendant or Ruby Franke. Further, these children were strictly prohibited from leaving the premises of the Ivins home under threat of further or increased punishment described hereinafter or going to jail. B. Inflicted and allowed another adult to inflict serious physical injuries upon the 2 children in her residence. So that is what, these are allegations about what Jodi Hildebrandt did. That's who the lawsuit is against. Not against Ruby Franke, it's against Jodi Hildebrandt. So she, number 1, inflicted, and also she allowed another adult to inflict serious physical injuries upon the 2 children in her residence. C. The defendant committed physical torture of RF, who was forced to do physical tasks for hours and days at a time. These included wall sits, carrying boxes full of books up and down stairs, and working outside. RF was forced to do outside labor without shoes, and in the summer heat in southern Utah. He was forced to stand in the direct sunlight for several days. He was forced to remain outside at all hours of the day and night for extended periods of time. These actions resulted in repeated and serious sunburns with blistered and sloughing skin. D. RF was denied adequate water several of the days he was required to remain in the summer heat, and he was punished when he secretly consumed water. E. RF was denied sufficient food, and when given food, he was given very plain meals, rice and chicken, while others in the house ate regular and more flavorful meals. F. RF was isolated from other people and denied all forms of entertainment, including books, notebooks, and electronics. G. In July, RF attempted to run away from the compound. When he was caught by the defendant and Ruby, he was taken home, and his hands and feet thereafter were regularly bound, including being tied to multiple weights. Many times the binding included 2 sets of handcuffs, one on his wrists and one on his ankles. H. At times, while RF was lying on his stomach, ropes were used to tie the 2 sets of handcuffs together so that his arms and lower legs were lifted off the ground in a hog-tied fashion. These bindings resulted in injuries to his wrists and ankles, where the handcuffs cut through the skin and damaged muscle and tissue. I. The injuries were treated with homeopathic remedies, cayenne and honey, and covered with duct tape. Then the bindings were placed on top of the duct tape. J. These actions caused severe emotional harm to RF due to the fact that they began in May and escalated through the summer months. Additionally, the defendant and another adult regularly sought to indoctrinate RF and convince him that the following. Number 1, he was evil and possessed. Number 2, he needed to willingly be obedient and avoid punishment. 3, the punishments were necessary to force him to repent. 4, RF was told that everything that was being done to him were acts of love. K. Both children were present in the home and saw these actions being taken against each other by the defendant and Ruby Franke. L. In these and other ways, the defendant caused severe emotional harm to RF and EF. M. Other than the binding and specific instances of abuse RF was subjected to, EF was subjected to the same treatment as RF. She was isolated and forced to do extreme and demanding physical tasks, remain outside, and denied adequate food and water. N. EF was told that these punishments were necessary for her to be obedient and to force her to repent, and were being done to her in order to help her. She was indoctrinated with the idea that defendant's extreme abusive behaviors towards her were acts of love. O. EF was also repeatedly told she was evil and possessed. P. These statements to her by the defendant and Ruby Franke convinced EF that she was evil and needed to go through these things in order to repent. Q. EF was further forced to work outside in the heat barefoot. She was forced to run barefoot on dirt roads for an extended period of time, repeatedly injuring her and her son and sunburning her feet. R. When examined by medical professionals on August 30th, these wounds were apparent by scabs, blisters, and sloughing off of skin. S. EF was physically forced or coerced to jump into a cactus multiple times. 9. Okay, now we're moving on to the rest of the complaint. On or about August 30th, 2023, RF was eventually able to escape from the defendant's home and contacted a neighbor. RF requested from the neighbor food, water, and that law enforcement be called so he could be taken to jail. This latter request was because he had been so indoctrinated by defendant that if he escaped, he would go to jail. So he actually told the neighbor, call the police, I need to go to jail. Instead of jail, however, of course, he was cared for by first responders and eventually admitted to the hospital for severe malnourishment, his body being emaciated, and for treatment of his many and serious wounds and injuries. On that same day, defendant was arrested at her home. After searching defendant's home, EF was eventually located in a closet of the home, sitting on the floor. First responders and law enforcement found her in an emaciated, food-deprived condition, and although conscious, was so emotionally traumatized and afraid that she would not communicate with them. Only after hours of reassuring her safety, calming her fears, and offering her food, she ate an entire pizza and part of another, were they able to coax her out of the closet so she could be taken to the hospital to treat her injuries, malnourishment, and emotional state. As a result of the foregoing, the state of Utah, through the Department of Child and Family Services, took custody of all 4 of the plaintiff's children in order to address professionally the emotional and psychological condition of the children, which had been so seriously and adversely manipulated and indoctrinated. The children are residing in separate homes, while in state's custody. The children's personalities, emotions, and psyches were so damaged and altered that it was beyond father's capability to restore them without professional intervention of state's resources through the juvenile court. This through a rehabilitation and restorative process directed and prescribed by the professionals treating the children. In order to restore his children to his care in their family's home, father himself has complied with the court process and has affirmatively sought his own regimen of professional therapy in order to coordinate not only with the children's treatment providers, but to gain an understanding of his children's conditions and needs and how to best facilitate the restoration of all of his children back to their former status as happy and healthy individuals and of a happy and intact family in their family home. The intentional and or negligent acts of the defendant have completely damaged and altered, for the worse, Kevin's marriage. The children's mother is in prison. All of his children's individual psyches, personalities, and behaviors, essentially dismantling, exploding his family and his personal life. The consequences of defendant's intentional and or negligent acts were foreseeable as to the effect on these children and to the effect on their father, the plaintiff herein. Based thereon, Kevin, for causes of action, alleges as follows. So that was all just the factual statements. This just tells us about the story, and now the complaint moves into the actual causes of action. So we're going to just go through the causes of action, and then we're going to discuss them to see whether there is merit in these causes of action. Number one, first cause of action, intentional infliction of emotional distress. So, defendant engaged in severe and intolerable conduct as set forth in this complaint. Defendant acted with reckless disregard of the probability of causing emotional distress to Kevin and to each of Kevin's children. Kevin suffered severe and or extreme emotional distress that was caused by defendant's conduct. As a direct and proximate result of defendant's wrongful actions and omissions, Kevin has suffered past and future economic, non-economic damages, pain and suffering, emotional distress, loss of quality of life, and loss of enjoyment of life. So the first cause of action listed in the complaint is intentional infliction of emotional distress. And we're going to get into all these causes of action very shortly and explain everything. Don't worry. Second cause of action, negligent infliction of emotional distress. Defendant engaged in conduct that she should have realized involved an unreasonable risk of causing emotional distress to the children, Kevin, and others. Defendant knew or should have known that her conduct could cause the sort of emotional distress that might result in illness or bodily harm or injury. Defendant's conduct unintentionally caused Kevin to sustain severe emotional distress, characterized by illness or bodily harm or injury. As a direct and proximate result of defendant's wrongful acts, and omissions, Kevin has suffered past and future non-economic damages, pain and suffering, emotional distress, loss of quality of life, and loss of enjoyment of life. That is the negligent infliction of emotional distress. And finally, the third cause of action is just ordinary negligence. And this is what it says here. Defendant undertook duties and responsibilities with regard to Kevin and the minor children and engaged in conduct all of which imposed upon her a legal duty to act reasonably and within the scope of acceptable behavior in her interactions with Kevin and the children. Defendant, as detailed in the statement of facts, breached her duty of care and of reasonable behavior and conduct. Defendant's breaches of duty negligence caused Kevin economic and non-economic damages as may be established upon proof at trial to include pain and suffering, emotional distress, loss of quality of life, and loss of enjoyment of life. Kevin is entitled to interest on all economic damages as may be established in accordance with the statute providing the same. Okay, and then there's some other paragraphs here, but that is essentially the complaint. So you've got the factual allegations, you've got the three causes of action, and now let's go into the actual causes of action, each one individually, to see whether Kevin Franke has any merit to these causes of action. First, let's talk about the negligence cause of action. Now, let's think about what negligence is. And remember, this is the plaintiff here is Kevin Franke, not the children. So you've got the fact that Jodi abused these children. That was an act of negligence to Kevin Franke. So right away, that sounds a little bit hard to wrap your head around, and it is. But let's just go through the fundamentals of negligence, and then we'll see how does it apply. Negligence is, the elements of negligence are the following. Number one, that there was a duty of reasonable care owed by the defendant to the plaintiff. And this is straight out of Utah law, by the way. which is essentially the same in all jurisdictions. But, to make things exactly as they're supposed to be, I just pulled from a Utah case. So that's number one. Number two is a breach of that duty. And this case, by the way, is Williams versus Melby. So number one, you had a duty. Number two, you breached that duty. Number three, that caused injury. Number four, that the plaintiff suffered damages as a result of that injury. So generally speaking, when you're dealing with a negligence claim, it's me to you. I have a duty to act with due care to you. And therefore, I can't run red lights. I can't speed through stop signs. And if I do, and you happen to be there and I cause an accident, that's called negligence. Here, this is not the negligence that Jodi acted or didn't act to Kevin Franke's children. It's the argument that by her abusing the children, that was an act of negligence to Kevin Franke. And my opinion is that it's probably not going to fly. That's not generally how negligence works. These are intentional acts that were done by Jodi Hildebrandt to Kevin Franke's children, and to argue that therefore is somehow negligent to Kevin Franke is going to be hard to prove. Now, also, there's another tort which we're going to talk about, which is more on point with what's going on here. There's no real injury that Kevin Franke suffered as a result of the negligence. Now, you're going to argue, what are you talking about? All the emotional distress and the mental anguish that he's suffered because of what he's learned happened that Jodi did to his children. That's true, and that is technically an injury. When we're talking about negligence generally, that's an emotional injury, and it's not so simple that emotional injuries are actually compensable in itself in a negligence claim. But there is another tort which is much more on point to this situation here, where you have a third party, Kevin Franke, the father, who's suffering emotional damage because of what happened to his children. So that actually falls into the tort, another tort which they did claim in their lawsuit, in Kevin's lawsuit, which is the negligent infliction of emotional distress. We're going to talk about that last, because first I want to get into intentional infliction of emotional distress, because this was another cause of action that was cited to in their complaint. So, intentional infliction of emotional distress. What does that mean? Well, that means the following. If somebody acts in an outrageous way, and outrageous means outrageous, not just sticking out their tongue at somebody or things like that. It has to be an outrageous act. So if somebody acts outrageously to an individual and there is another person standing next to that individual, that other individual can have a claim for intentional infliction of emotional distress. Remember, this is emotional distress. So when it comes to intentional infliction of emotional distress, this is what the Utah case law says about that. And this is White versus Blackburn. That there has to be outrageous conduct, like we said, by the defendant. And the defendant had an intent to cause emotional distress. So the defendant had an intent to do that to you. Or the reckless disregard of the probability of it causing emotional distress to you. So that's what goes into intentional infliction of emotional distress. So what about this? The problem with intentional infliction of emotional distress is the following. Here you have Jodi Hildebrandt, who's absolutely intending to cause damage to the children. The question is she intentionally causing emotional distress to Kevin Franke? Is that what she's doing? And if you want to say, well, it's hard to argue that she's intentionally abusing the children so that it will harm or cause emotional distress to Kevin Franke, so that's going to be hard to prove. But maybe there's the other part of that. The other part is that she recklessly disregarded the probability of her actions, her abuse to the children, causing emotional distress to Kevin Franke. So maybe that second part will work for Kevin Franke. So again, you have the intentional action, and that's what she's doing here. She's intentionally abusing the children. And now she's also, what you have to argue is that she's recklessly disregarding the probability of her actions causing emotional distress for Kevin Franke. That's how you would have to argue this. Now, here's where the only issue can really come. And that is that the question is, when someone commits this tort of intentional infliction of emotional distress, does that other person have to be present when that the defendant did that intentional act? Does that person have to be present and watch it in real time or not? And here is where Utah law is not 100% clear about this. There are some cases which seem to suggest that there does have to be a presence of the plaintiff at the scene of the crime, should we call it? And there's another case which could be argued that maybe it's not necessary. So what I'm going to point you to is the Restatement of Torts. Now, the Restatement is a treatise, and in terms of what type of authority or binding authority it has, it doesn't have binding precedent, binding authority on any court, really. It's just a treatise. But a lot of courts cite to the Restatement, and it's very persuasive. So the Restatement of Torts says the following. One who by extreme and outrageous conduct intentionally or recklessly causes severe emotional distress to another is subject to liability for such emotional distress, and if bodily harm to the other results from it, for such bodily harm. So this is when I'm causing emotional distress directly to you. I come over to you and I do something in your face intentionally outrageous to specifically cause you harm, and I cause you bodily injury, so I'd have to pay you for both. Number 2, where such conduct is directed at a third person, the actor is subject to liability if he intentionally or recklessly causes severe emotional distress to who? To a member of such person's immediate family. So it has to be in someone's immediate family. Okay, so we're still good. We're still good because Kevin Franke's child is immediate family. And so under the Restatement of Torts, if a person intentionally commits a tort or does outrageous conduct, something outrageous, and you're a third person who's there, but they're doing something outrageous to your child, like in this case. So then then you're still within this cause of action. But listen to how it continues. To a member of such person's immediate family who is present at the time. So according to the restatements of the Restatement of Torts, which is the second edition, it has to be that Kevin Franke would have been present when the abuse was going on. And if he wasn't present, even if he learns about it later, as we all learning about it, and of course he's the father, so it affects him a lot harder, but that's not going to qualify for intentional infliction of emotional distress. So again, there are some cases in Utah which seem to suggest that there does have to be a presence there at the scene of the crime. You have the Restatement of Torts that's clear that it has to be that you're there to see the outrageous conduct, and only then do you get into the cause of action of intentional infliction of emotional distress. So that cause of action is also a little bit flimsy whether that's actually going to carry the day. So now let's move on to the final cause of action that is listed in the complaint, and that's negligent infliction of emotional distress. And that really is where what I was talking about with negligence, how it really more applies in that scenario. Because here you have Kevin Franke claiming emotional distress. Essentially, that's what he's claiming. And that emotional distress is connected with Kevin Ruby's action, which even though it was an intentional action to the children, but it was a negligent action to him. So that's where more it would fall in. Now, it's not either so clear that it would qualify for negligent infliction of emotional distress. Now, before we get into that, I just want to tell you that there's actually this specific cause of action. This tort has a special place in my heart. And the reason for that is that the first assignment that I was given in law school, in my first year of law school, before I really knew anything about legal research and writing, we were in this class. It's a required class, legal research and writing, and you're given assignments to research different areas of the law, different causes of action, and we were required to write a memo on a certain scenario, which I was very surprised, like one of my first assignments in law school. It was a certain scenario, and we had to analyze it using negligent infliction of emotional distress, which I've never heard of before. And I started researching some of those cases and talking about it, and I was very confused at the time. But don't worry, everything's going to be very clear at this time as we go through this. So negligent infliction of emotional distress is actually not so clear whether it is a recognizable tort throughout different jurisdictions in the United States. It really depends on which state you are. There are some states that don't recognize negligent infliction of emotional distress at all. So the first question you have to ask yourself is this a recognizable tort in Utah? And to answer that question, you have to go to a case called Ray Johnson versus Rogers. Now, listen to the tragic facts of this case. The facts of this case are the following. At approximately 10 p.m. on April 16th, 1982, plaintiff Ray Johnson and his 8-year-old son, David, were waiting for a walk signal before crossing a street in downtown Salt Lake City. So father and son out for a walk. Now it's 10 p.m., okay, but they're out for a walk. They're about to cross the street. They're waiting for the walk signal. They're doing everything right. A truck crossed the intersection and jumped the curb, killing David and injuring Ray. So David's the son. He's standing next to his father, Ray Johnson. Truck jumps the curb and kills Ray's son in front of his own eyes, and also injures Ray at the same time. And after, of course, everything that happened in this case, it eventually got appealed, and it got to the Utah Supreme Court. So the question that the Utah Supreme Court asks first is, before us on appeal, there's some other issues also, but before us on appeal is the question of whether a cause of action for negligently inflicted emotional distress exists in Utah, and if so, under what circumstances it exists. So number one, does it exist as a tort? And number two, even if it does exist as a tort, what circumstances? How do you get in the door to be considered that you can argue for this cause of action of negligent infliction of emotional distress? So the court goes on, this opinion goes on, it's a very interesting opinion, I'm not going to go through the whole thing, but the opinion goes on and explains that there's really 3 different standards that you could apply to a negligent infliction of emotional distress. One of them is called the impact rule, one of them is called the zone of danger rule, and one of them is called a foreseeability standard. And eventually after the court, and there's a concurrence here, and I'm not going to get into all the legalese here, but what comes out is the following, that they adopt something called the zone of danger rule. And the zone of danger rule is actually brought down, where would you think? In the Restatement of Torts. And this is what they adopt. So this is what it says in the Restatement of Torts with respect to negligent infliction of emotional distress. Number 1, if the actor unintentionally causes emotional distress to another, he is subject to liability to the other for resulting illness or bodily harm. So you're subject to liability for this emotional distress if you unintentionally, right? Negligence means that you unintentionally cause the harm to another person. So if the actor what? If the actor should have realized that his conduct involved an unreasonable risk of causing the distress, otherwise than by knowledge of the harm or peril of a third person, and from facts known to him should have realized that the distress, if it were caused, might result in illness or bodily harm. That's number one. Number two is the following. The rule stated in subsection 1 has no application to illness or bodily harm of another, which is caused by emotional distress arising solely from harm or peril to a third person. So now this is getting into more of our situation. Our situation is where the harm was caused to a third person, and now you are the one claiming emotional distress because of that harm done to the third person. So when can you claim that? This is what the restatement says. Unless the negligence of the actor has otherwise created an unreasonable risk of bodily harm to the other. So the negligence of the actor has to create an unreasonable risk of bodily harm to you. So you want to argue, you want to claim that you have emotional distress. You've been inflicted, this person acted with negligence and inflicted on you emotional distress. The only way under the restatements, which is what the Utah court says, what the Utah court adopts, is that you also had to have risk of bodily harm to yourself. That is what they say here. So, applying that to our case, was Kevin Franke ever have a risk of bodily harm to himself while his children were being abused? And the answer to that is no, right? He did not have that risk. And therefore, negligent infliction of emotional distress is also probably not going to carry the day for Kevin Franke in his claim as well. So my overall analysis of this complaint is negligence is probably not going to carry the day. Intentional infliction of emotional distress is going to be very difficult to prove, especially because you have the restatement of torts, which says that the person has to be present when the damage was done. And negligent infliction of emotional distress also, the Utah case law is clear that there has to be that you also were in risk of having bodily harm to you as well, which Kevin Franke obviously never had the risk of having bodily harm while his children were being abused by Jodi. So that does not seem that it's going to carry the day for him. He was not considered in that zone of danger, and therefore this whole lawsuit, I think, is not on the most sturdy feet right now. Well, that's my analysis of it now. We'll continue to cover it and watch it and see what happens with it. And if you haven't yet, please subscribe, like, and we will see you next time.